Justice Jackson?
So I think you're saying in response to Justice Kavanaugh that this isn't disrespectful from the Sentencing Commission's perspective because it didn't take Congress to be removing the ability for individualized consideration in particular cases.
That's correct.
And with respect to Justice Barrett's point about how this would operate with respect to a judge who had policy disagreements with a mandatory minimum, I guess I didn't take your argument in this case to really be about that at all. And by that I mean, I thought what you were focusing on in this case is the fact that there's a sentencing disparity that has been created such that your client, if he was sentenced today, would not have the same sentencing exposure as Congress now has determined it, because Congress has changed the statute. So it's not the court saying, I don't think people who do this sort of thing should be subject to this length of sentence. It was Congress who said that in this situation, right?
That's correct. And Mr. Rutherford here served 19 years. He falls within the policy guidance that says you have to serve for more than 10 years before you even become eligible to invoke this particular argument.
Right. So in some sense, this is giving the opportunity for a consistency with what Congress has determined about what people who've done this sort of thing should get.
Yes, and doing it, though, in a contextual way that takes into account the various circumstances of that inmate's behavior in prison, age, illness, family circumstances, and the like.
And so in some sense, the compelling circumstance here is that the change, this is kind of going back to Justice Kagan's point in the first case, that there's been a changed circumstance with respect to how long Congress believes that people in this circumstance should be sentenced. And even though Congress didn't necessarily want that to be applied categorically, there's nothing to preclude courts from taking that into account in an individualized way in combination with all sorts of other factors if a person requests it.
That's correct. And the 1984 Congress used the words that enabled that particular outcome, Justice Jackson. And I would just note in the original appeal, Judge Ambrose affirmed the sentence but said it's unthinkable that in any system the sentence should be this long for the two robbery offenses that my client committed.
Can I just ask you one other thing? Because I noticed that there are differing views about the order of operations, just as a practical matter. The judge who was trying to entertain a compassionate release motion. And I think it might matter because sentencing disparities are actually prescribed by Congress as a consideration in 3553A. So if you have to do 3553A, then you're going to take into account the kind of thing that the government is now saying that you don't in the extraordinary and compelling circumstances world. So what I mean is, what is your view of how this works? Lower courts, I think, are starting with the extraordinary and compelling circumstances factor with the Sentencing Commission's guidance, and then they turn to 3553A. The government seems to suggest that you start with extraordinary and compelling factor without the Sentencing Commission's guidance, then you go to 3553A, and then you consult the Sentencing Commission as a check or a limitation. But the statute suggests there's even another way of doing it, which is that you start with 3553A, and then you go to extraordinary and compelling with the Sentencing Commission. So what's your view on the order of operations in this?
Justice Jackson, I confess that it has been a while since I did sentencing cases in the government, but I would say reading this particular statute, I don't know where this 2- or 3-part step where you just start negating things if they don't meet a certain threshold. The statute is worded as if certain things happen, then such and such, and that to me suggests that this is a gestalt. It is a totality of circumstances kind of inquiry. Which order you do them in, we trust district judges to get to the right outcome based on those circumstances.
And you admit that you see that 3553A does require consideration of unwarranted sentencing disparities.
Yes.
And it's in this statute, too.
Yes, and it seems odd that you would say, well, we're only going to consider it one if we've nuked you out of a position to be able to bring that argument based on